There's one for when a lawyer is contacting you. There's one for a notice of validations of debt. There's one for no parking rule. There's one for validations of debt. Hmm, these are all different. Okay. Now, under what circumstances would I use the Volenti Non Fit Injuria? Well, I would use it as a general defense, or I would use it if I'm being contacted by lawyers regarding a debt. Ah, okay. Because it's a maxim of law, so lawyers would automatically know what it means and they'll just back off. If I'm in court and a debt collector is suing me for a debt that they quote unquote bought, I could use that as a defense. Why? Because to a willing person, it's not a wrong. So if you willingly go out and buy bad debt that you know people are not paying on, how can you cry damages when you are the one that went out and buy these debts and I didn't force you to do anything? So my general defense would be a Volenti Non Fit Injuria, right? So if a debt collector is saying I owe an alleged debt, but I never got any paperwork to substantiate this claim, which that also means that a validation of the debt wasn't done. And I know before any debt can be assumed as valid, the consumer must be given the opportunity to dispute the alleged debt. So my question was, or is, did you send out a validation notice for the consumer, for in this case me? Did you send out any notice with this alleged debt for me to dispute the accuracy of this alleged debt? If you did, where's the proof? And if I get it now, okay, what would be my response? Okay, did they send it on a model form B1? Because that's what the new law requires. It's supposed to be sent on a model form B1, and it has all the validation questions as required per 12 CFR 1006.34C. So you see how when you start asking yourself questions, it prompts you to find certain answers? So as you do that, it's going to stick. Like it just sticks. So I know if I see a debt collector's first attempt to contact me, I know that first attempt should be in regards to a validation of debt. I think there's a feedback here. Where did she go? Oh, is she still with me? Did I lose her?
April?
No, it wasn't April.
It wasn't April.
It was
Yes, I'm still here.
yeah. So it's really going in. So in the university, you remember the debt collection triage? There's a document. It's called the debt collection triage paperwork.
I'll go and find it.
Yeah, it's in there. It's in there for a fact. I know that it's in there. It has about 16 questions. These are the questions that I go through. And as I go through these questions, whatever either I'm going through or you guys are going through, I fit it with the questions. And once I fit it with the question, it gives me my next step. All right, let me give you another example before you go. Let's say that I have a client that came in with medical collection. Let me use that as an example. There's a few things. Hold on, I'm getting a feedback. Cynthia, I think your mic has a feedback. So I'm just going to ask you to stay on mute. You can raise your hands for sure, and then we'll get to you in a minute. All right. So when it comes to a client with medical collection, the first thing I want to know from medical collection is how much is the balance? That's the first thing I want to know. Why? Because of the law that says medical collection $500 or below does not get reported. I know that, so that's the first thing I'm going to ask. So if it's medical collection, I have 4 to 5 questions for medical collections alone. So I don't need to do a cease and desist. I don't need to do the other stuff because I need to go through my medical collection questions first. So is the medical collection under 1 year old, right? Is this an invalid medical debt? Meaning, did you get an itemization of bill of quantity? How did they bill you? What did you get billed for? Were these services provided? And if they were provided, what's the proof that they actually did what they were supposed to do? And then you charge me this amount, I'm disputing it, which makes the medical balance invalid. Because you're charging me for services that were not rendered. That's fraud. The amount in dispute right now is invalid. It's an invalid amount. Invalid medical debts cannot be reported on your credit. So I break it down like that. All right. I think you're good. I hope I didn't overwhelm you right now, but yeah, that's just when I'm going through, that's how I do it. I'm going through and I'm looking at all the pieces and I'm asking myself questions.
Thank you. That's what I needed to hear.
Absolutely amazing. Back to you, Shante.
Thank you, Ms. Coleman. Okay, up next we have Win. How are you tonight?
My guy, what's good, Win?
I'm doing great, Daraine. Good evening, everybody. How's everybody doing?
Amazing. Every day is the best day of my life. Talk to me. What you got?
Great, great, great. I got two things. So I have a question. If you're being served a notice to go to court for a debt for collection,
Mm-hmm.
can you would you recommend at that time would you also file you know what I'm talking about? Where you actually go at the damages at that time?
No. So you're talking about if someone is suing you or you are suing someone?
No, someone's suing you. Would you also, when you answer to that, would you also file uh, um like you don't talk about where you actually go at the damages in that process?
No, you wouldn't do it there. Right, that means you need to defend yourself. So when you're being sued or they do a statement of claim, right? You need to do what is called an answer. So now you're in
Right,
defense mode, right? So
right,
we
okay,
have there's a template. It's not in the university, it's in the connoisseur program. It's called an answer to a lawsuit or something like that. It's
okay,
inside of the connoisseur program. So an answer consists of one of three answers, right? You either admit, you either deny, or you lack sufficient information to admit, so you deny. Okay? It's
okay,
not a it's not you explaining, oh, I was sick, I was in a car accident. No, that's not what that period is for. The answer to a statement of claim is the simplest thing that a consumer will do in the process, and that can solve about 90% of the debt collection issue. So in the statement of claim, they might say, oh, the company name is LVNV Funding, and we bought the debt from Capital One, and something like that. I'm gonna deny that statement because I don't know if that is true, right? I don't know. Like they might say, defendant name is Daraine Delevante. He lives at 123 Main Street. Well, I'm gonna admit that if that's my address, I'm gonna admit that, yes. So I'm gonna say I admit. But if they're stated, like, don't assume anything. If they're gonna say account number asterisk 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 123 belongs to Daraine, deny. I lack sufficient evidence to admit to the fact. So it's answering their claim, and each statement of claim must be answered. If there's 10, you can't answer 5 and then leave 5. You got to answer all of them.
So I guess I was thinking if they actually have you to the point where you actually go to court, the word I was looking for is since they have you there already, would you not do a counterclaim at that time for damages?
Well, you could, but you got to think about defending yourself first before you want to go there.
Okay,
Because remember,
okay,
if they're coming after you, you have to defend yourself. And how you're going to
right,
defend yourself is, did they follow FDCPA laws? Is the account past the statute of limitation? Do they have legal right to even collect? Was there an assignment of contract? Was there proof of the purchase? Did they do all the validation notice? They were attempting to collect and they still did not validate the alleged debt, and all debt collection activities stopped. once the consumer starts or initiates the validation process. Once the validation process is in place, all debt collection activities must stop, which include the reporting of the account to any consumer reporting agencies or any action being taken, which in this case would be a lawsuit or arbitration or whatever.
Okay, cool. All righty. I have a client that received a notice. It's Locke's Legal Group. It says Locke's Legal Group LLP is a law firm which may be deemed a debt collector
It's a
for
law firm.
Ali Financial, right? Ali Financial, um, as a server for Ali Bank, referred your account, and then whatever for legal proceedings. How would you respond to that?
Did they send the client a dawning letter for them to verify the alleged debt?
No, pretty sure they did. He got this, and this is what they sent to me.